Hi everyone, thanks for joining in. This is as Kelly said, this is the second part in the series about education advocacy, and today we're going to be largely talking about suspension, expulsion, and exclusion, and accommodations within that framework. Just a reminder that I often say before every presentation is just because this is a public presentation, it's being recorded, so the best thing to do is to avoid asking any overly personal questions. This is not really the context for legal advice. It's best to pose questions in a more general way. What I would recommend is that Arch offers a summary advice service, so if anybody has any questions of a more personal nature and want to talk with a lawyer about that briefly, they can always give us a call and we can set up a 1-hour summary advice appointment to allow you to canvass some of your issues with a lawyer. The other proviso before I start is just related to the fact that the suspension, expulsion, exclusion process is incredibly complex. And so today I just won't be able to give sort of a comprehensive play-by-play how-to of exactly how one would appeal a suspension or expulsion or anything like that. The goal today is really to give you a sense of what are the tools that exist in the legislative framework to allow you to effectively advocate, really struggling with that one, effectively advocate for your child. It's going to be centered around sort of a human rights approach in this context and some of the arguments that you can raise. So I guess I just need to figure out how to switch the slides. So I briefly in the last one talked to you about what Arch is, but just to review, we're a specialty legal aid clinic specializing in disability rights. We're the only one in Canada, and we offer a wide variety of services in a number of priority areas, education being one of those areas. So again, we have lawyers here who know all about advocacy in the educational context for students with disabilities, so please feel free to call. So, as I mentioned in our last presentation, we really focused on, what are some of the advocacy tools that you can use to get an inclusive type of placement for your child. Now, a lot of the principles I talked about were a little bit broader and apply to a lot of other situations, including exclusion. So now what we're really going to sort of focus on are situations in which a child with a disability has been suspended, expelled, or excluded, and what the human rights implications of that is. Now, ultimately what a lot of this boils down to, a lot of these issues, is obviously behavioral issues. Students with disabilities sometimes exhibit certain behaviors, many of which should be properly accommodated and managed by a school, but there are situations in which that does not occur. So that's sort of the focus of our presentation. We're really going to be talking about behavioral issues, just because the majority of these cases involve that. So a quick overview of suspension and expulsion. Now, there are two types of suspension and expulsion. The first is, there are two types of suspension. The first is there is what's known as a discretionary suspension. And that largely involves sort of a number of more minor incidents. I mean, these like swearing at a teacher or something like that. And the Education Act under Section 306 basically gives a principal the power to choose whether to suspend over some of these incidents. Now, the Education Act actually does outline somewhat specifically what a lot of these incidents are. And they include things like, a threat of bodily harm, possession of alcohol, stuff like that, which, is serious, but not quite as serious as some of the other some of the other types of things that can occur in a school setting. Now, there are 4 things that you really should remember about a discretionary suspension. The first and second is that you're entitled to notice of that suspension, which sort of should lay out the reasons for what's happened. And you're entitled to appeal that suspension to the school board, right from the get-go, basically. The right to appeal is a pretty significant thing in this context, and it's really important to know or to familiarize yourself with the school board's local procedures in the appeal process. The Education Act, it really gives a lot of school boards a lot of leeway to develop how their suspension and expulsion process works, which is one of the things that makes my job a little bit more difficult, because there are 72 school boards in the province, and a lot of them do things a little bit differently. So I don't want to, sort of get you bogged down in the procedural stuff, except to say that the important thing that you really need to know is you need to go to your school board's website, review their policies on procedures, and if they're not accessible, you need to ask for them, just so you have a sense of what the timelines are. You can expect when you get the opportunity to make submissions, all that sort of thing. It's really important to familiarize yourself with that. One of the other things that it's really important to know about discretionary suspensions and mandatory suspensions as well is that under the Education Act, they can really only last for 20 days maximum. So, if you have a suspension that seems to be lasting longer than that for some strange reason, it's really important to know that legislatively they can't do that. Now, in my experience, school boards are pretty aware of that, so that doesn't often happen. But that time cap is still very important to be aware of. The final thing that I think is really important to know about discretionary suspensions and appealing them is that when a principal is deciding whether to suspend a student or expel a student or anything along these lines, anything I'm going to talk about here, when they are deciding whether to do this, there's a number of things that the Education Act mandates that they must consider. And I'm going to get into a little bit more detail about that at a later, in a couple slides. But I just want to point out that, for all of these types of suspension and expulsion, there are some sort of legislative tools that you can use to really point out to a principal that, this is really what you need to be considering when you're making a decision. And if they don't consider it, then you can push back and sort of say, well, this suspension or expulsion or whatever it is inappropriate for those reasons. So I'm going to get to that in a second. The next, I think I'm already being a little bit too slow. The next type of suspension, as I mentioned, is called mandatory suspension. And that functions in a slightly different way. It involves a lot of more serious behaviors, such as bringing a firearm to school, committing assault or sexual assault, punching a teacher, and they require some sort of medical treatment. In those cases, the Education Act gives the principal literally no discretion as to whether they are to suspend a student or not. Hence the name mandatory suspension. What it says to a principal is that they must suspend the student, and then they must then undertake an investigation to really sort of figure out what happened here. And during that investigation, you can't actually appeal the suspension. And so the purpose of the investigation is that the principal is really supposed to make a recommendation about whether to expel a student or not. In a lot of cases, if they go through the investigation and say, this is meritless, this is groundless, they'll recommend not expelling the student. And in those cases, what you typically do is you just default back to the regular suspension appeal process that I just spoken about earlier. But if the principal does recommend expulsion, what ends up happening is you have to go to an expulsion hearing at the board level to allow the school board to confirm whether to expel a student. Now, this is pretty highly regulated by the procedures under the Education Act. There's a number of things that the principal must provide to a parent in these circumstances, like notice, and at the expulsion hearing, you have to have the opportunity for submissions. You have to give parents or advocates or whoever it is the opportunity to tell their side of the story. And it also gives a right to appeal to an outside tribunal, somebody that's not part of the board, to sort of make a final ruling on whether a suspension or expulsion was appropriate under the circumstances. Now, under the current framework, the appeal at the expulsion hearing goes to the Child and Family Service Review Board, and there's a whole variety of circumstances and regulations that you should be aware of at that point. But what I would recommend is if you're sort of hitting that expulsion hearing or appeal of an expulsion hearing, that's when you really need to start consulting legal advice. I'm just looking through what I really wanted to say about that. I think the overriding concern here, though, is again, you have a number of these mitigating factors, which when the investigation is occurring, when a decision about whether to expel is being made, the principal or decision maker must again really consider these mitigating factors and figure out if any of them are at play and whether they suggest that a student should not be suspended or expelled. So let's move along here. So on to the mitigating factors. Now, these are sometimes a little bit difficult to interpret, I think. But the important thing to know about the mitigating factors is that they largely apply specifically to disability-related issues. So, for instance, under Section 2 of the regulation of the Education Act, when a principal is deciding whether to suspend or making a recommendation to expel under the mandatory suspension procedures, they have to consider whether the student has the ability to A, control their behavior, and B, whether they understand the consequences of their behavior. If they don't have that ability, then this sort of suggests that a decision should be made in which a student is not suspended or expelled. And this is largely in line with the Ministry of Education's policy on progressive discipline, which really emphasizes that, discipline should not be used in circumstances where a student doesn't have the necessary ability to control their behavior or really understand what those consequences are. It sort of speaks to the idea that discipline in those circumstances is really just counterproductive. It's not helping anything. It's not, helping a student correct their behavior in any sort of way. Sort of countervailing against the ability to control their behavior and the ability to understand the consequences is whether a student presents an unacceptable safety risk by their presence. So that's also something that a principal must consider in either making a decision to suspend or expel, or a recommendation to expel. The other thing that's really important to know is that under Section 3 of the regulation, the principal must also consider a number of other factors, like the pupil's history at the school, whether a progressive discipline approach has been implemented, whether they have an IEP or an individual education plan, and whether the behavior is a manifestation of that of their disability, and whether appropriate accommodation has been provided. In circumstances where appropriate accommodation has not been provided, and where a student does have an IEP, sort of outlining that accommodation, then this again pushes against the idea that a student should be punished in that context. You can see there below as well, there's also a consideration of whether suspension or expulsion is likely to aggravate or worsen the conduct, which is sort of, again, what I was referring to before about, is discipline a productive approach here? Now, the important thing, I think, to understand about these mitigating factors is, again, they're rooted in the Education Act, and they provide a grounds to argue at a suspension or expulsion hearing that a student should or should not be suspended or expelled, but also that these legislative requirements mirror a lot of the obligations the school board has under the Human Rights Code of Ontario. The Human Rights Code largely, it doesn't explicitly state this, but the interpretation is pretty clear that a student with a disability needs to be properly accommodated before you can implement any sort of punitive measure on them for disability-related behaviors. And so, I guess the point is that here there's a really strong grounding in the law for the idea, again, just to underline it, that you cannot punish a student with a disability unless you've provided proper accommodations. And in a lot of circumstances, what these accommodations largely amount to are behavioral management plans or safety plans. They're basically, an indication that the school has taken steps to assess the behavior of a student, and they've implemented measures to try to mitigate those behaviors. So when you're facing a suspension or expulsion, and you believe it's unfair, some of the questions you might be asking of the school is, have they provided these appropriate accommodations? Or have they, gotten the proper experts in to really assess what may or may not be needed? In a lot of cases we've had, there's often a history of these behaviors coming up over and over again, and they've slowly escalated over time, become more serious, and the schools have largely ignored them until this point when the problem became unignorable. And so, in that context, you really have to question, well, have you properly accommodated that student? Have you really done everything you can to ensure that they have meaningful access to education? If these problems have been evident for a long period of time and nothing was done about it, no behavioral support plan or safety plan has been put in place, it's difficult for a school to claim that, we should punish this student, especially when they don't understand or appreciate the consequences of their behavior. So that's sort of what, the crux of the argument often is in these circumstances. And when I'm advocating for people in these circumstances, this is largely the argument that we would deploy against this, a decision to suspend or expel. This is essentially what we'd be saying to a school board, is that no, these problems have been evident for a long time, very few steps have been taken. How can you punish this student at this point? How is it productive to do that? So that's sort of just to underline. I know that was like just crazy fast and difficult to probably to process, but I think that it bears mentioning again that the major argument, that's what the major argument is there. A lot of the other stuff is procedural details, again, which are very important to be aware of, especially the timelines for appeal. But the basic argument that you make, the one that is well supported under existing human rights law and in the Education Act, is you can't punish a student without properly accommodating them. So exclusion is like or sort of similar to suspension or expulsion in a way, and it's often we get calls where people are often using the phrase exclusion interchangeably with suspension and expulsion. But they're not the same thing. Suspension and expulsion is a highly regulated process with a number of procedural protections in place. It's clearly tracked by the ministry. Every incident is sort of logged. Like there's statistics taken. Students with disabilities, whenever they're suspended, it's noted that yes, we've suspended or expelled a student with a disability. Exclusion, on the other hand, is somewhat different. It represents a very small piece of the Education Act, and is very ambiguously worded, but it conveys a very broad power to a principal. Namely, it gives the principal the power to exclude a student, any student or any person really, if in their judgment that person's presence would be detrimental to the physical or mental well-being of the pupils. So that is pretty broad generally, and doesn't really give a principal or the school a lot of guidance as to how the law expects that this power is to be used. Now, as I mentioned, in addition to being highly unregulated, there's not a whole lot of data to sort of tracking how this is being used, unlike suspension and expulsion. We actually did some work on this a couple years ago and tried to figure out, what is the frequency at which students are being excluded from school. And so we sent out, I think, 10 Freedom of Information requests to the 10 largest boards in the province. And only 2 of the boards came back and said, yeah, we're actually tracking this and when it's used. The closest we could come otherwise was that, almost half of all elementary principals and 40% of secondary school principals have, quote, recommended that a student not attend their school. So it's unclear whether they're actually invoking that power in that circumstance. But the point is again, highly unregulated. It's not clear when and where this power is being used by the school board. Now, much like the previous discussion we had about the suspension and expulsion, the Human Rights Code also imposes similar obligations on the school board in terms of the use of the exclusion clause. Now, again, I said it's highly unregulated, but there is this minimal bit of law that does apply to this. And again, it basically says the same thing. The Human Rights Code says essentially that a student should not be punished unless they've been properly accommodated prior to this. And a principal, again, must provide those accommodations short of the point of undue hardship. Now, undue hardship is frequently the issue in these circumstances, and I think I'm going to talk a little bit more about that in a second. But the important thing to remember here, again, is that in most cases, the Human Rights Code essentially rules out excluding a student for disability-related behaviors unless they can prove that that proper accommodation has been provided. So the important thing to do in these circumstances, and is to always need to get that decision in writing immediately. If someone is threatening exclusion, you need to contact the school board, and if they have not given you a letter outlining their decision to exclude using 265(1)(m), the provision I was just talking about, and the reasons for their usage, then you need to get that, because again, it's unregulated, it's sort of slippery. There's no requirement necessarily to provide notice under the Education Act, and there are circumstances we've encountered where it's just sort of invoked casually, and there's no sort of paper trail around that. Any lawyer who's going to help you in these circumstances really needs that sort of documentary trail to follow. Now, again, I sort of alluded to this. After you get the decision in writing, you should call a lawyer for advice in these circumstances. This is a pretty serious issue, and it's difficult to navigate, again, because it's such a highly unregulated provision. The other thing that is really important to ensure is that school is actually offering alternate programming during the exclusion. They can't just unilaterally say, oh, you can't come to school, so our obligation to educate you is over. There really needs to be an alternate program put in place, at least in the interim. And that does not mean you're agreeing to the exclusion. It just means that they have an obligation to continue educating your child regardless of whether your child is actually in the school at that time. Thank you. So ultimately, in a lot of these suspension, expulsion, and exclusion cases, a lot of what the issue boils down to is undue hardship. So in many cases, the school will claim, well, we tried to accommodate a child, but it was too much. It was too much of a safety risk. It was or too expensive, or whatever their rationale is. Now, the undue hardship framework does consider safety concerns in its analysis. The legal definition of undue hardship includes the cost to a particular organization and whether any health and safety considerations are imposed on that organization. So, there may be circumstances in which a school, really has hit that point where it's going to cause undue risk to personnel to actually accommodate a student in I would say in sort of the immediate circumstances. I think our position in a lot of cases would be that, that is not an enduring situation. There should always be a way to accommodate a student. But, for the short term, there may be situations where a school meets that threshold. But it is important to remember that it's not a low threshold. Undue hardship is undue. It requires a school to, not just allege that there's a safety risk. There has to be sufficient evidence of that risk. And B, just a little bit of risk is not going to trigger that threshold. You need a significant amount of risk. So undue hardship is not something that yields easily. Or sorry, I guess undue hardship, to say it another way, undue hardship is not something that schools can meet easily. Essentially, it's a high threshold to meet, and they need some pretty concrete evidence of that threshold. Well, I think I did talk about this. If there are significant health and safety risks, which preclude accommodating a student in the immediate future, then the school could be legally justified in suspending a student for a limited period of time. We're sort of getting back into the suspension and expulsion sort of discussion. Now, I think I'm actually on the half an hour time frame. That was all very quick. So if you have any questions, I'd invite them now. I think we were trying to keep this presentation to about an hour, so I think we have sufficient time to address any questions if there are any. I don't know, Kelly, do you have anything that you want me to cover?
I think that's a good overview, Luke. I don't know if folks are here from outside of Windsor, but I know we have a big issue with exclusion down here. So I don't know, maybe if we needed to go further into depth on that, or is there any documentation or any guides about exclusion for families that have been used?
So that's, sorry, I'm just reading another question here. Yes, that's a good question. That's also often very difficult. So I've heard, and I shouldn't be saying this on a recorded program because this is just rumor. I've heard that the ministry is coming out with some guidelines for exclusion. However, at present, there is not a whole lot of guidance on this provision, which is, again, sort of why I, drift through it quickly, because a lot of the guidance on this is really going to be in the form of, like, what does the Human Rights Code impose upon a school? That's really where a lot of the law guiding this comes from. There is not a whole lot out there, aside from maybe a paper that I have written discussing this provision. So I know that's not a helpful answer, but what I always recommend to people is, in these situations, you need to contact a lawyer for legal advice. They're just very complex. They're very serious, and they can get away from you if you sort of let a school drift along with an exclusion for too long. Yes, so the paper is actually on Archie's website, so I'd invite you to go take a look at it. It's a legal paper, so it's a little bit heavy on the jargon, and it does make some some arguments that they can be advanced in opposition to an exclusion. One of the things I would really emphasize about exclusion is that because it's such a serious issue, and because there are so few procedural protections sort of built into the legislation surrounding exclusion, there's a really good legal argument to be made that a school should not be able to use, or a school should not be able to circumvent the restrictions on suspension and expulsion, like, say, the limit or the time limit, by using exclusion. Now, again, that's sort of that's a legal argument, and I don't know if that's something you'd want to try to advance on your own. So, feel free to take a look. The paper is, I think, current as of 2016, I believe, so it's relatively new. But yeah, aside from that, I can't think of too many other resources related to exclusion. I see that. Okay, where's the question? So some examples of what is and is not undue hardship. It's a very difficult question, and I think a big part of the reason that it's so difficult is that undue hardship is, a flexible legal concept that can really only be definitively nailed down by a tribunal, assessing all the evidence available to them after, long litigious proceedings. They're the ones, the ultimate arbiters of what is and is not undue hardship. But what I would suggest is that, in circumstances where, say the cost is not especially great, like something like providing an educational assistant to help manage behaviors, that is not undue hardship on a school. They employ a number of educational assistants across the board. You know, they have large budgets. They can move stuff around. You know, what might be undue hardship in the sort of interim in terms of safety, I would say, you know, like maybe a student who's assaulting, you know, a teacher on a regular basis, for circumstances or for short-term circumstances where there's no real good way to manage their behavior. There's no behavioral support plan that's been implemented. It's going to take a little bit of time to do that. You know, that might be a circumstance in which you're gonna hit undue hardship. It's a very difficult line to draw in a lot of circumstances, and I think the best I can suggest to you is that, you know, for your particular situation, just give us a call. You know, talk it through with a lawyer, and hopefully we can give you some guidance on what may or may not be undue hardship in your situation. That being said, again, you know, the ultimate arbiter of a lot of these things is the Human Rights Tribunal. A really good resource if you're feeling very studious, you know, is to read some of the decisions on education that have already been released. I'm just trying to think. Moore v. BC, the definitive case on education and human rights, is an excellent. It contains some excellent information on undue hardship, in particular in relation to cost. I'm just trying to think what would be another good case. You know, if I think of any others, I'm sure that you know, we can share that with attendees and that sort of thing. Are there any other questions that you'd like me to address? Anybody?
Hello, can you hear me?
Hi.
Hi, I'm calling from near Kingston, and we have a clinic here, a community legal aid clinic, who has a lawyer who is dedicated to doing what it sounds like you're doing in your organization. There are very few and far between groups that take this on. So if you're not from either Windsor or Kingston, where does a family or a parent or a student go for assistance? That's one of my questions. I'd be very curious because this is something that parents know nothing about.
Yeah, that's an excellent question. I think, well, in answer to the question, you know, one of the places you can actually call is us. We have a provincial mandate. So if you live anywhere in the province, you can give us a call, at the very least for summary advice to discuss this sort of situation.
Okay.
So that's one of the first things I would recommend, not to promote myself too much. I believe as well, Justice for Children and Youth, another specialty legal clinic that is actually just down the hall from us, who also has a provincial mandate. You know, they may be able to address some of these issues as well. They typically will represent a child for the most part. So, you know, they have a little bit of a different process than us. In terms of, you know, if you're ever at the point where, you know, you're seriously thinking about, you know, more extensive legal action or something along those lines, I think the Human Rights Legal Support Center is actually an excellent place to call about that sort of stuff as well. They, you know, I don't know all of their lawyers, but I know a couple of them have some experience with education law matters. One of the other things, not to sell, you know, some non-legal options short, is the Ombudsman of Ontario. There have been cases, I believe, and I'm struggling to remember their last annual report, but I know exclusion was featured in that. And so there are cases where, their involvement can really help in terms of exclusion and that sort of thing. I'm just trying to think of any other resources that may or may not exist out there. I think there's also the pro bono educator. Pro bono, I can't remember what it's called. It's a pro bono law education project, and so there are through Pro Bono Law Ontario. I think it's Pro Bono Law Ontario. There are a number of lawyers who may take on education law issues of this nature if you go through this program. That being said, one of the reasons that we specialize in this area is because we have identified it as a gap and in service provision, and it's a really complicated area of law.
It sounds very vague and confusing for parents, and lawyers who don't do it must find it awful as well.
Sorry, I missed that last part.
I was just saying that parents must find it very, very confusing with all the vague legalese.
Yes.
And taking things out of the Education Act and using a human rights approach. And then you get very confused, I'm sure.
Yeah, and I mean, to be honest, even for lawyers, the issues are not always so straightforward.
Yeah.
So it's a very difficult issue, especially exclusion. Suspension and expulsion is a little bit more straightforward because the procedures are listed in the Act and in the regulations, and schools provide, or various school boards will provide guides that sort of lay out what their process is. But you're right, sort of when you start to drift over into the exclusion area of things, it gets very fuzzy. Part of what my paper actually argues is I'm not even sure that the provision, 265(1)M was even meant to do this, and that was just an interpretation imposed afterwards. But the prevailing understanding, at least for the moment, is that they can use it for this purpose. I see, Kelly, the nowhere to turn report. I think it was. I want to say it was. Oh yes, Archie's provincial. Okay. So are there any other questions at all?
One more being typed right now, Luke.
Sorry? Oh, a few more?
We have one more being typed right now by Beth.
Oh, perfect. Okay. And feel free, everyone, to just ask me to repeat something. I know I sort of sped through it, and I think it was just related to keeping everything within. We were hoping to keep everything within an hour, but I'm more than happy to repeat anything or go over something again.
It's Donnelly again, and I just wonder, Kelly, whether you or Arch would be able to create a one-pager list of these. It would be very, very useful for us here in Kingston, of the list of your resources that you mentioned. I've written some down, but it's not easy to catch it all. And if there were some phone calls or websites we could look at, or we do have a number of issues in our area that are problematic.
So actually, what I would say is, I actually, in the very first webinar I put on, there's a list at the end of the slides of a lot of the resources that I talked about. I'm pretty sure that Justice for Children and Youth and our contact information is on there, as well as the Ombudsman and the Human Rights Legal Support Center. So I think those, I don't know, are those available, Kelly? I don't know.
Yes, we didn't post them online, but we're more than willing to email them to people if they want the slides.
Perfect.
And we're also going to post the first webinar, but we had some issues with recording that we have to edit it down. It was too long. We had trouble shutting it off. So once we get that fixed, we will post it, and that will have that information as well. But I can also email you the slides if you want to.
I think, slides would be really great.
Okay.
Even in advance, so that taking notes is.
Well, that's a good idea. Okay. If
I'm
you
gonna
want
have to get on my game to make sure I
you can do it.
my email in the chat for you if you don't have it.
Okay, thank you. I'm on the phone. I'm not on my internet. Oh.
My email is ensemble@communitylivingessex.org, which is ensemble@communitylivingessex.org.
Okay, I think I actually have your email.
Okay.
I'll email you.
Okay, sounds good.
That's great.
Sorry. Okay. All right. So I see Beth. So that's okay. Perfect. So I guess I think that's it in terms of the questions. Unless you have any other thoughts, Kelly.
No, I don't think so, Luke. Thank you so much. That was very informative. Oh, I think Beth is typing a question. I don't know. Hang on one second. Oh, just a thank you. But yes, thank you everyone for participating. And Luke, thank you so much for the another great presentation. And we will get that out to people, the slides and the video presentation, very soon. I can send the slides out tomorrow, but the video will probably take a couple of days.
Great.
Okay.
All right.
Thank you so much, everyone. Good night.
Thanks, everyone. Have a good night.
Good night. Bye. Thank you.
Bye-bye.